Real Estate Board of Greater Vancouver. Introduction to Commercial Leasing. And this is copyright 2016 Real Estate Board of Greater Vancouver. So let's go down to the objectives. Just give me a second here. Oh yeah, course description. This course offers an introduction to commercial leases. It is designed for the residential realtor who may be interested in furthering their understanding and knowledge of the basic components of writing a binding offer to lease. The landlord-tenant relationship is very different than a seller-buyer relationship. There are many important issues that can adversely affect this business relationship if the lease agreement is poorly understood or poorly constructed. Landlords and tenants look to realtors for their expertise and guidance in completing a successful leasing process. In this introductory course, participants will be introduced to how a commercial lease is created and its basic component parts, certain significant provisions, and the different types of commercial leases. Using a case study, participants will take part in a hands-on activity to prepare a simple and binding offer to lease. The concepts which will be learned will have application to commercial retail units, office space, and warehouse premises. Learning objectives. Upon completion of the course, participants will be able to 1. Define the basic terminology of commercial leases. 2. Describe the different types of tenancies. 3. Explain the essential elements of a commercial lease. 4. Identify the different types of commercial leases. 5. Recognize the common provisions of commercial leases. 6. Identify key differences between leases of strata lots and standard commercial premises. 7. Describe the differences between guarantor, indemnitor, and covenanter and when to apply them. 8. Successfully prepare a simple and binding offer to lease, including avoiding key risks and errors. All right. We'll skip the table of contents and the introduction. This course is specifically addressed to commercial leases, while conceptually a number of items which we will be discussing will be pertinent to residential leases. We will not be considering residential leases. Residential leases are governed by the Residential Tenancy Act of British Columbia, RTA. The RTA sets out certain very specific statutory requirements which must be included in each residential lease. There is available a standard residential form of lease from the website of the Residential Tenancy Branch. It is called the Residential Tenancy Agreement, RTB-1, at their website. All right, let's go. 1. What is a real property lease? A lease is an agreement by which one party, the landlord, gives another party, the tenant, the right to occupy all or part of certain premises or lands for a term in consideration for the payment of rent. A lease gives an interest in land. Exclusive possession of the premises or lands is given to the tenant. The interest in the land remaining is called the reversion. By comparison, a license does not create any right or interest in the premises or the lands and does not confer a right to exclusive possession. What are the main differences between residential and commercial leases? So, the terminology, the contract and applicable law, different types of tenancies and provisions are expressed, terminated, and how rent is applied, rights and responsibilities of landlord and tenants, how disputes are settled, how they are negotiated. 2 types of tenancies. Fixed-term tenancies. A lease for a fixed term provides that the tenant will have the right to occupy the premises for a certain specified time. At the end of the term, the tenant will be required to deliver up vacant possession of the premises to the landlord. Most, if not all, commercial leases will be for fixed term. A fixed term can be for months or years. B. Yearly tenancy. If a tenant is in possession of premises with no express time limitation and rent is paid quarterly or yearly, it will be a tenancy from year to year. To terminate a yearly tenancy will require 6 months prior notice. C. Month-to-month tenancy. If a tenant is in possession of premises with no express time limit and rent is paid monthly, it will be a tenancy from month to month. To terminate a monthly tenancy will require 1 month's prior notice. 3. Negotiation of preliminary lease agreements. A. Introduction. Parties wishing to enter into a lease agreement usually engage in a series of negotiations that will result in the formation of a document which sets forth the basic business terms for the leasing that are specific to the respective parties, the intended use, and the premises. The most common forms of these documents are a letter of intent, also called a memorandum of understanding, and the second one is a binding offer to lease, also called an agreement to lease. Alternatively, the parties could go straight to the preparation of the actual lease agreement itself. The form of lease will depend on the bargaining power of the parties. The benefit of going straight to the lease is that until the lease is actually signed, there is no agreement between the parties and either party can walk away. Some parties use this as a cost-saving measure since they are not spending time negotiating a letter of intent or offer to lease. The norm, however, is the preparation of a preliminary document. The document will include the business terms upon which the parties wish to proceed. As the conditions of the preliminary agreement will be incorporated into the actual lease document, each party must ensure that all items important to it are included in the preliminary document. If they are not, it is unlikely that the party will subsequently be able to have them included in the lease document. B. Preliminary agreements. As stated, the most common forms of preliminary agreement are the letter of intent, which is intended to be non-binding, and the offer to lease, which is intended to be binding. You have to be cautious when drafting a letter of intent because even though it may contemplate the execution of a formal lease document, it may actually bind the parties to a lease relationship. Depending on the parties involved, they may have their own specific forms that they insist on using. You will see this often in the case of national retailers or national franchisers, and the form of the party providing the document will be favorable to that party. C. Letter of intent. A letter of intent is an expression of the intention of the parties to enter into a formal lease agreement and is typically non-binding. The purpose of a letter of intent is to set out the major business terms to be included in the formal lease. While it is intended not to be legally binding, it does create a moral obligation on the part of the parties to ensure that the formal lease document reflects the terms and conditions of the letter of intent, and parties following this And parties following this moral obligation usually consider themselves bound by the terms, even though the letter of intent is not legally binding. You have to be careful to ensure that the letter of intent remains a non-binding document, because, depending on the language of the letter of intent, a court could determine that it is legally binding on the parties. The basic items that will be included in a letter of intent will be the names of the parties, a description of the premises, the length of the term, the rental rates, and any other major issues of importance to the parties. While it is intended that a letter of intent not be binding, there may be provisions in the letter of intent that are intended to be binding, such as confidentiality provisions. A letter of intent must include a specific statement that it is not binding on the parties. If such a statement is not included, a court may enforce the letter of intent if all the essential terms of a lease are present. We will discuss these elements shortly. It is also necessary to ensure that there is a statement in the letter of intent that a formal lease agreement must be executed to reflect the parties' ongoing relationship. D. Offer to lease. An offer to lease, when executed by both the landlord and the tenant, and possibly an indemnifier or guarantor, will be binding on the parties. An offer to lease will contain the major financial and business terms found in a letter of intent, but in more detail and must be in writing. While usually it is a single document, it may not, in certain circumstances, be a specific form of document, but may be a series of correspondence between the parties, which together contain all of the essential terms. The parties must ensure that all matters essential to the business transaction and which are of specific importance to each party are included. The failure to do so may result in items of importance to a party not being included in the formal lease agreement. The difference between a non-binding letter of intent and an offer to lease is that if the formal lease agreement is never executed, the offer to lease will become the lease agreement governing the relationship between the parties. An offer to lease may often refer to a standard form of lease, being that of the landlord or the tenant, depending upon the strength of the respective parties. With this inclusion, that means practically, if a party is not satisfied with any term of the standard lease, it has little choice but to execute the lease as presented, failing which it may be subject to a claim for damages. You must be careful to ensure that there is a provision in the offer to lease whereby the parties have the ability to review the lease and seek changes to the terms and conditions other than those terms which have already been agreed upon in the offer to lease. If an agreement cannot be reached, then either party should have the right to terminate the offer to lease and walk away. This way, a party is not placed in a situation of having to sign a lease which it finds offensive. The offer to lease and formal lease cannot be at odds. If so, the courts have held that the lease is a repudiation of the offer to lease and that the parties have reopened the negotiations. It is beneficial to attach the standard form of lease to the offer to lease to avoid future disputes. That way the parties will have an opportunity to review it prior to signing off on the offer to lease. It is not unusual for an offer to lease to contain a provision requiring the tenant to execute and return the form of lease within a specified time frame. Incentives for the tenant to return the signed lease are: A. The tenant will not be given possession of the premises, and B. Any tenant inducement referenced in the offer to lease will not be paid until the lease is signed and delivered to the landlord. A landlord should not give a tenant possession of the premises until such time as the formal lease has been signed and delivered by the tenant. If the lease is never signed, the offer to lease will govern the relationship between the parties. From the landlord's perspective, an offer to lease is usually deficient in terms of the landlord's rights in the event of default by the tenant. The landlord will then have to rely on common law and statutory rights and remedies. Conversely, a tenant should never enter into possession until such time as the landlord has executed the lease and has provided a fully signed copy to the tenant. E. Drafting the lease without a letter of intent or an offer to lease. It may be that the parties choose not to spend the time and money to prepare a letter of intent or an offer to lease. In this case, they may go straight to negotiating the formal lease. Until the lease is fully negotiated and signed, there will be no binding agreement between the parties. The parties will determine whose form of lease is to be used. A provision may be included in the lease which states that until it is fully executed, it is not binding on the parties. 4. Essential elements of a lease. To create a binding and enforceable lease, there are 5 basic elements which are necessary. These elements are A. The identification of all parties to the transaction. This includes the landlord, the tenant, and any indemnifier guarantor. B. A description of the premises to be leased. C. The date that the term commences. D. The length of the term of the lease. And E. The rent. There is a 6th element that is any there is a 6th element, and that is any other material terms. However, the 6th element may or may not be required. As to the essential items, the parties must agree on all of them. This is referenced to as consensus ad idem, or a meeting of the minds. And if there is no consensus ad idem, there will be no agreement. If the 5 essential elements are found in the offer to lease, then in the absence of a formal lease document, the offer to lease will become the lease agreement between the parties. If a lease purports to be subject to the Land Transfer Form Act of British Columbia, then reference must be made to Part 2 of that Act. The reason for this is that short form clauses in the lease have the broader meanings set forth in the Act. We will look at this in more detail later on in the course. We have determined that there are 5 essential elements to a lease. We now need to consider them in more detail, and we'll continue in another video for this. Thanks for watching and listening, and check out